Do you think that the time will come where parents can get it together to have a class action suit?
The Law Project for Psychiatric Rights, PsychRights, would really like to bring more of these actions, and at this point, our financial resources have basically been exhausted, and so we're not really in a position to do that right now, and we're working on that. One of the things that I think could be extremely effective is that most of the psychiatric drugs given to children and youth on Medicaid is not allowed under Medicaid. And it turns out that 4 times the number of poor people, percentage of poor children on Medicaid get given neuroleptics than children on private insurance. And children in foster care are given it 9 times more than the average on Medicaid. And so there's a huge amount. I mean, this is where it is, and what's happened is that the drug companies have really figured out that there's no pushback on the cost of this from the government. They just pay it. But interestingly, it's not really allowed under Medicaid. In the Medicaid statute, only covers drugs that are what's called for a medically accepted indication. And that's an indication that's approved by the FDA or, quote, supported by these drug references called compendia. So if it's, to put it in something that people understand, if an indication is, or diagnosis is not approved by the FDA, then it's off-label. Okay. So Congress didn't say we won't pay for any off-label, but we'll only pay for off-label if there's scientific support for it. And together, those are called medically accepted indications. And at least half of the psychiatric drugs given to children are not for medically accepted indication. I mean, these neuroleptics are given to children for sleep. I mean, this is abhorrent because, I mean, first off, why isn't the child sleeping? I mean, let's deal with, what they're, what's preventing them from sleeping is probably something going on with their lives, so let's help them. But even if you were to give something for sleep, you shouldn't, be given this sledgehammer. So in any event, we brought a suit against 32 defendants in Alaska on this, including the prominent child psychiatrists, the big child drugging agencies, and 3 big pharmacies, because the pharmacies are the ones that are actually getting paid for the prescriptions, and so those are false claims. And each prescription carries a minimum penalty of $5,500. So that adds up real quick. But the reason we include the pharmacies is because the big ones at least have enough money to interest the lawyers. But the real focus is on the psychiatrists, or it could be pediatricians or any other doctors doing it. Because, again, each prescription carries a minimum penalty of $5,500, and if they got tagged with this, it would bankrupt them, and the idea would be that that would scare the other doctors into at least putting a brake on the practice. Well, the basic response of the courts was, well, the government knows all about it and isn't doing anything, so why should we care? And that's, technically, it's called the public disclosure bar, is what they ruled under, but that's not actually what the public disclosure bar says. So we went all the way up to the 9th Circuit Court of Appeals, where they basically said that, and then issued this really 1-page memorandum that said you're out of luck, but you can't cite this as precedent. So we think it's still a viable approach. We had hoped that PsychRights would get a ton of money out of this and then be able to bring other lawsuits, such as challenging some of these FDA approvals. I mean, for example, we know that the approval of Risperdal in children was based on the fraudulent work, the fraudulent and corrupt work of Joseph Biederman of Harvard Medical School, who basically promised Johnson & Johnson Janssen that if they funded his child mental health center to the tune of millions of dollars, he would conduct research that would demonstrate that Risperdal should be used in children, young children. So we know that that was fraudulent work, and so we would love to have the resources to actually challenge those that FDA, starting with that FDA approval, and there are other ones too. And there are lots of other things we would like to do, such as filing a suit under 42 U.S.C. Section 1983, which is commonly known as Section 1983, or civil rights actions. And Section 1983 provides that basically you can sue someone who deprives you of your civil rights or violates your civil rights under color of state law, which basically means under the authority of state law. And so that's what we have with children in state custody being given these drugs. And we think that's a completely viable approach to do a class action. But again, we don't really have the resources at this point to bring such a case.